Welcome back. So River State gets our attention now, particularly with that appeal court order setting aside the state's high court's decision that stopped Martin Amewule and 24 others from parading themselves as state assembly lawmakers. So what are the interpretations to this court order? Joining us for this discussion is Mr. Samuel Oge, who is a lawyer and former member, River State House of Assembly, Emoha, between 2011 to 2019. He joins us via Zoom from Port Harcourt. We also have joining us Mr. Richard Wokocha. He's an associate professor of public law, Department of Public Law, River State University, who also joins us virtually from Port Harcourt. Thank you very much, gentlemen, for joining us on the program. So, Mr. Oge, I'm going to start with you now, and it's important to first of all establish, what your deductions are about this Court of Appeal ruling, because there are so many interpretations to it. So, let's feel your pulse on the ruling first of all.
Well, good morning. Thank you for having me. Let me also greet my teacher, Professor Wokocha. Good morning, sir.
Good morning, David. Well done.
Thank you. Like you said, there have been different interpretations to the judgment of the court yesterday, which need not arise in any way. The court was very clear in the position they took. The position of the court is to the effect that Justice Wale, who sat at the trial court, had no jurisdiction to entertain the matter, and so whatever orders he gave was a nullity, was null and void. It means that there was no order given, the orders never existed. It means that it follows, therefore, that whatever that had happened following the order given by Justice Wale amounts to nothing. Now, what are those things that have happened? One of those things that have happened is that Justice Wale, when he gave the order, said that Martin Amewule was not the speaker, or should stop parading himself as a member of the House and the Speaker of the River State House of Assembly. That presupposes that Martin Amewule and the 25 others who were barred by the pronouncement of Justice Wale were, until that pronouncement was made, the Speaker and members of the River State House of Assembly. So, by the decision of the Court of Appeal yesterday, the meaning is clear, very unambiguous, that look, Justice Wale, you don't have the requisite jurisdiction to go into this matter. And so everything you did, or in the words of the court, that you labored in vain. It means that it amounted to nothing. So the status quo that was before Oko went to court was that Martin Amewule is the speaker, or was the speaker, and that the court, as sat yesterday, confirmed that situation. That is where we are.
Okay, if I may quickly come in there, the judge has ruled that it has jurisdiction to hear the matter, and that the state high court cannot hear the matter, so to speak. But has the judge ruled, the judge of the Court of Appeal now ruled on the substance of the matter, which would be that whether or not Martin Amewule and 24 others can still hold office, having defected from the PDP to the APC?
I don't think that matter was before the court. The issue of defection, or the tenor of defection, was before the court of appeal. Now, it was Okojumbo who went to court to say, look, these people having defected, purportedly having defected, should vacate the office. Now, the trial court gave that injunction. Now, the court said, look, you shouldn't have given the injunction in the first place because you do not have the powers to do so. Jurisdiction is not an issue we should argue on social media or on the media. It is a constitutional matter. If you do anything without jurisdiction, our law, the professor will confirm this, is that everything you have done outside jurisdiction is a nullity. That's what the court said. Now, if Oko Jumbo has come to say, look, I am the speaker, and of course we know he's not the speaker. I will tell it's good we have the background to this. About December last year, the Martin Amehule-led House of Assembly suspended about 3 or 4 members of the House, deriving their powers from the House. The Legislative House's powers and privileges Act 2018 empowers the House to discipline an erring member, that in the exercise of that role assigned to them, suspended this person. If you go further to section 15 of that act, you'll find where the law says, please, once you are suspended, until the suspension is lifted, you do not have any business with the House. We do not have any business with the House. So if once you are suspended, you remain suspended. As far as I am concerned, as far as the law is concerned, as far as the Universal House of Assembly is concerned, Oko Jaja and his colleagues who are suspended by the House remain suspended. Now, back to your question. There is no contention whatsoever. The court says so. There is no contention about who is the speaker. The court says, look, Martin Amehule is the speaker, notwithstanding what the lower court said, even though it was said out of jurisdiction.
I wonder if obiter dictum is playing out here again, on this set during this discussion. But let's take it now to your teacher, Professor of Law, Professor Wokocha. Professor Wokocha, I'm sure that you have reactions to what your student has said.
Thank you. I also greet my learned friend, Honorable Loge. Honorable Loge was only my student for a while, and we are now colleagues. And I respect his position completely. On the issue, I think what he has stated is practically the facts. There is only one point that is not being gotten right, and that is the fact that the lower court did not declare seats vacant. The declaration of vacancy or the process of a person vacating a seat is completely a legislative affair. It does not leave any room for judicial participation. The judiciary only participates when there is a dispute as to whether the Constitution has been complied with properly or not. So if you look at Section 109, it states what happens. It says a member shall vacate his seat if the things listed under subsection 1 happens. And then it goes on to say that this is so, however, effect shall be given to this, however, that at the next session, the speaker or a member shall present the fact that a member has vacated to the House. And if the House is satisfied that that is so, it will not take the necessary steps, which is giving effect to the vacation of seats. So where the judiciary, where Section 272(3) talks of the role of the Federal High Court, it is if anybody disputes that process that has taken place, the person is to take that matter to the Federal High Court, not to the State High Court. So I think that the judgment of yesterday terminated the process that was handled by the State High Court, presided over by Honorable Justice Wale. And the Court of Appeal said, look, you did not have the jurisdiction in the first place. Let's leave the fact that you acted too early. There was no basis, no urgency requiring you are granting the ex parte order, the first one. But even the subsequent one where you had the parties, you acted without jurisdiction because this matter can only be handled by the Federal High Court. So if that is the case, what is overturned is the order of the High Court, the State High Court. And what is that order? The parties that approach the State High Court ask the court for a specific prayer. the seat of these gentlemen having been declared vacant stop them from parading themselves. Not that it should declare the seats vacant. And the court did not declare the seats vacant. The court only granted those interim and subsequently parading themselves as members of the House of Assembly of vacation of seats or declaration of vacancy of those seats was a legislative activity and has
Professor
not been set aside. The Court of Appeal yesterday did not make any reference.
Professor,
yeah.
Pardon me if I may butt in there. We lost you for a bit because of the connection, the virtual connection. Perhaps you could rewind a little bit from where you talked about jurisdiction.
Okay. So I was saying the jurisdiction of the court is jurisdiction to entertain any dispute over the exercise of that authority. Any dispute arising as to whether or not Section 109 and Section 109 sub 1 and sub 2 were properly carried out. And not that the court will be the one to declare the vacancy. There is no role for the court in Section 109. Its role arises only where there is a dispute as to whether it's been properly done. So if, for instance, I defect from my political party and I am a member of the House, and my defection is considered as having met the provision of Section 109 sub 1, and the House subsequently declared my seat vacant. If I feel that my defection had a good reason and that it does not fall within the provision of Section 109, it's my responsibility to approach a federal high court to distinguish between my defection and the defection intended by the Constitution to have that effect. It is the federal high court that will declare whether or not the declaration of my seat as being vacant was properly done or not. And not that the court will declare my seat vacant. It is not a judicial responsibility. You can look at Section 109 sub 1, which lists the conditions that lead to vacation of seat, and look at subsection 2 of it, which again states what the House must do after that to give effect to subsection 1. So I think that's where the mix-up is coming from. As Honorable Oge rightly observed, issue of defection was not before the court and could not have been before the court. That was not an issue before the lower court. The issue before the lower court was to stop the people from parading themselves as members and officers, their seats having been declared vacant by the House. So the only thing the court set aside yesterday was the order of that court stopping them from parading themselves. That means you can continue to parade yourself until the question is properly raised before the Federal High Court, which the Court of Appeal said is the court with the right, with jurisdiction to deal with that matter. So I think that that's the only place where there is a difference between our views.
If I may have your take. So simply the judge, the Lord Justices, by the way, simply said to the people who filed that case at the State High Court, you went to the wrong court.
Yes.
And now there are two people. There are two people claiming speakership. So in the eyes of the law, because they've defected, that's still under contention. You said they can still parade themselves as lawmakers. But who is the Speaker of the House under the law? In this situation...
Can I come in now?
Yeah, I was asking Professor Wokocha, you can come in after him, sir.
Okay, good. Now, if you are talking about the position of the law, you look at the Constitution. If the Constitution says you vacate your seat if you defect without reason or without the reason stated in the Constitution, which is, I think that is well known now, that your political party is in crisis in such a way that it can no longer continue, or you are part of a faction of your political party that has merged with another political party that is also in the House. If that is the case, your defection is different from what is intended by Section 109, subsection 1. But other than that, the court says when that happens, along the other reasons that have happened, all that requires to be done is that the House will meet and that fact will be brought to the attention of the House, and they will give effect to subsection 1, which is declaring that seat vacant. So if that has happened, in the eyes of the law, there are only, as it is now, because I think 28 people altogether have resigned, so to speak. 7 defected, 1 resigned. So 28 people have vacated the House. It means Rivers State House of Assembly is left in the eyes of the law with only 3 members. Only 3 members.
All right, Mr. Oge, let me take it to Mr. Oge. Mr. Oge, you can go ahead, please.
The leather professor is completely in agreement with me, but there is a missing link, which I also would like to explain. Now, at the point where the Martin Amehule declared the seats of the 4 persons vacant, the learned professor refused or had not averted his mind to the fact that they ceased to be members of the House of Assembly until recalled. The implication of that is that since they are under suspension, they cannot transact any legislative business of the House. That said, now I also want to remind our guests and other listeners here that the situation of who becomes the speaker, or let's say in the event of the purported defection, the professor has told us that Section 109, Sub 2, also says what should happen. And what is that? What should happen is that the speaker shall give effect to that. And who is the speaker? Martin Amehule is and remains the speaker. So somebody like you and I, who are not member, or a member who is already under suspension, people are mixing that up. And I want that clear, that 3 persons or 4 who are already under suspension are not in the cozy of their offices or bedroom come to say that we have declared the seats of their colleagues vacant. That doesn't happen. The law doesn't give them such powers. Now, okay, if you go further, the assembly, in this case, Rivers State House of Assembly, is a creation of law. And the Rivers State House of Assembly functions according to law. And the law states how a Rivers State House of Assembly can sit, or any other assembly for that matter in the country. What are those conditions? There must be a quorum. There must exist a quorum before you transact a competent legislative business. And in the case of Rivers State House of Assembly, what is the quorum? The Constitution specifies that there must be 1/3 of all the members. A Rivers State House of Assembly with 32 members, 1/3 of it must be 11, excluding the presiding officer. So the question now is, was there any, at all times, even the professor has agreed with me, 27 or 28 persons have been on one side. At what point did any other person form a quorum to transact any legislative business? Of course, there had not been any such time.
Right.
Despite the fact that they are suspended and remain suspended, or that suspension had not been lifted, they also, assuming that suspension had been lifted, they also does not have the powers to conduct any legislative business. So what you find in Rivers State is, or going on in Rivers State Assembly, is somebody in his bedroom, somebody in his parlor will just go on air and say, I have done this.
Well, Mr.
Does the law allow? Of course, the answer is no.
So clearly, where we stand right now, even both of you do not agree on who or what the legitimate state assembly is right now, Okojombo or Amewule.
We are in agreement on the fact that Martins Amewule is the Speaker of the Rivers State House of Assembly.
So, Professor Wokocha, is that your view as well? Just a moment, Mr. Oge, just to be clear, Mr. Wokocha, Prof, is that your view as well? I just want to confirm from Prof if that's also his view on this. Okay, I understand that Prof may have dropped off the call, but we'll try to reconnect. What it appears to me now is that, yes, this case is before the court. The court has made a pronouncement, but it looks like we're still back to the point where the controversy was really hot, such that if the governor wants to maybe approach the State Assembly, who does he approach? Is it a Martin? Okay, I think Professor Wokocha is back with us now. Prof, I was asking you if you agree with Mr. Oge that the Martin Amewule-led assembly is now the legitimate State Assembly to transact legislative business with. All right, Mr. Oge, please go ahead now. My question to you is, does this really solve the challenges, the impasse that we've been facing for months now in Rivers State?
Well, it's just the situation we find ourselves, where some persons have decided that they would not obey the courts. And our rule is that when a court makes a pronouncement, when a pronouncement is made by the court, no matter how uncomfortable, no matter how perverse you may feel, or the pronouncement is, the first thing you ought to do is to obey. Like you rightly pointed out, a court of competent jurisdiction, the Federal High Court, presided over by Justice Omotosho, has made pronouncement on this matter. And that only would have sealed this further agitation. But what happens in Rivers State is people now will go from one court to the other, embark on forum shopping, moving from one court to the other, moving from courts that do not even have jurisdiction, or some faceless persons will just go and, instead of appealing a judgment, or in the first place, comply with the court's directive to say, look, this is the situation. Or if you are aggrieved, the best you can do in the circumstance is to proceed to a higher court, in this case, the Court of Appeal.
Just a moment.
But nothing of such is happening here.
Just a moment, Mr.
Nothing of such is happening.
Pardon me to come in now. So let's look at the implications now, because I think a lot of people in Rivers State and even across the country want to know the implication of this, and maybe this can also be backdated. So we've seen the Okojombo-led assembly making decisions, screening, for example, caretaker chairmen who have now been sworn into office. We've seen the screen of commissioners, commissioner nominees as well. We've seen decisions made. So does this judgment, does it invalidate that? Secondly, who should the governor approach now, well, in the meantime, if he needs to conduct any legislative business? So first, for the previous actions taken, and now for the future actions to be taken.
The governor has no problem. He has no problem. But only to the effect that he chooses to create problems for himself. There is a House of Assembly in existence. There is a House of Assembly in existence with all the powers to make laws. They have the quorum, they have everything it takes to make laws. Now, the governor or any other person for that matter does not need to go to court to derive its power to make law. That is what they did. They were looking for help. They resorted to self-help. When they saw that they cannot sit, they resorted to self-help. They went to the court to say, give us an injunction. Now, to answer your question directly, there is no problem. The governor has no problem. And he need not create further problems for himself. There is an assembly. Now, the actions you enumerated here taken by Okojombo were predicated on the decision, the injunction given by Justice Wale. And the Court of Appeal has said, look, you do not have powers to do what you did. And in law, when the court says something is null and void, it means that it is of no effect. It never existed. What that simply means to a layman is that Okojombo never existed. So every decision taken as a result of the injunction Okojombo got from the court that empowered him to sit, recall that Martin Amewule was sitting before this injunction came. And the court has said yesterday, look, whatever Okojaja said, did, whatever actions, is a nullity.
All right, Mr. Oge.
The implication is that whatever action that was taken by Okujaja, whatever action,
Okojumbo, right?
whether it's three, whether three persons were able to form quorum.
All right, Mr. Oge, if I may button, so I want you to attend to a few things because there are so many courts and judges involved in all of this. First, I'd like you to speak to what was presented before the judge at the Federal High Court, Justice James Omotosho, because I know he spoke about the issue of the budget that was presented to a House of 4. He said present it to a properly constituted House. Does that imply now that he recognizes, or the law recognizes Amiwula as a speaker, or you will help us break that down? Second part is that we've not seen the CTC of the Court of Appeal, and I know there are 11 prayers. One of the prayers is the fact that whatever Okojumbo has done, even parading himself as member or speaker, there should be an order to that effect that he's not, and actions and resolutions and all of that meetings should be a nullity on one hand. So when the judges were making pronouncements yesterday, did they speak to all of these prayers? Because it looks like we jumped on one, which everybody is now celebrating. The third thing is the fact that what happens when the Speaker of the House defects and somebody is supposed to declare that seat vacant in the eye of the law? If you can help us break it down.
Can I tell you, the professor also acknowledged this, that the Speaker of the House gives effect to whatever happens. So if the Speaker does not give effect, it's not an automatic stuff. The Speaker gives effect to whatever. Assuming that there was a defection, it goes to the
Speaker that has vacated the state.
Excuse me. Assuming truly there was a defection, is the Speaker that gives effect to that. In the absence of that, then nobody can leave. Nobody, no member can come to say, look, I have declared the seat of another member vacant. That is not our law.
But that's not the language of the law.
Prof, you can come in. Prof, you can come in.
Provision of the Constitution.
Prof, go ahead, please.
Yes. Yes. Honorable Oge raised quite a number of issues. First, on the issue of speakership, or what happened when persons were suspended. If persons happen, they are still the issue is that it affects as residents. So the House
Professor Okocha,
I don't know what's does not stop us. No, because our forum.
Prof, if you can hear us.
Which says the House perform.
All right, Professor Okocha, apparently we're having a challenge with establishing a solid leader connection. But Mr. Oge, I guess Prof was speaking to the difference between resignation and suspension and to the status of the question I asked. You know, although you didn't answer all the questions, you answered one. I don't know whether I have a response.
For the interjection, my dear brother, Prof cited section 109. I will be pleased if we go further to read to the general public the provisions of section 109 sub 2. By your kind permission, if you allow me, I will read so that we know what the position of law is. Section 109 sub 2 states, the Speaker of the House of Assembly shall give effect to subsection 1 of this section. So, however, that the Speaker or member that shall first present evidence satisfactory to the House that any of the provisions of that section has become applicable in respect of a member. Now, if the Prof comes back, I will allow him to read the same section he cited. That only confirms the position of our law. The Constitution says the Speaker shall give effect to it. Now, having answered that, I'll go to the second leg of your question. You asked about the decision of Justice Omotosho. Like I said, the decision is there, unchallenged. Justice Omotosho gave some declarative orders and said, look, whatever you did without going to Martin Amewule is a nullity. In fact, he was specific to the point that he said, represent your budget to Martins Amewule. What that means is that the Martins Amewule is recognized as the speaker, and the 27 members, 25 other members recognized as members of the Rivers State House of Assembly. But ordinarily would have stopped there, if not for the, like I said earlier, foreign shopping or somebody somewhere trying to create unnecessary problem for himself. We cannot create our own laws. There is law for everybody. This law is not a Rivers State law. This law is not, the courts we are talking about is not Rivers State Court or Samoge's Court. This is Federal High Court, and the law of the land says when a court takes a decision, you obey. If you cannot choose to obey or not to obey, then you go to the court again, another court, maybe of coordinate jurisdiction, to ask for the same thing. That doesn't help us in this situation. So the implication is that this is the second time a court is making a declarative statement on the affairs of Rivers State House of Assembly. First is Justice Omotosho. His position was clear, unambiguous, and has remained unchallenged. Yesterday, the justices of Court of Appeal have said, look, Justice Wali, you were in a hurry to do what you did, even when you do not have jurisdiction. So everything you did is a nullity. And let me also mention one fact so that you don't ask the question you're asking again, the implication. Okojombo derived his powers from the pronouncement of Justice Wali. Now that the Court of Appeal has said, look, everything Justice Wali said is a nullity. It simply follows that whatever Okojaja did, or whatever Okojaja did as a result of the...
Do you mean Okojombo, Mr. Oge? Do you mean Okojombo?
It's a nullity, that's it.
Do you mean Okojombo or Okojaja?
What did you say?
Do you mean Okojombo?
Okojaja.
Okay.
So, Mr. Oge, let's just backpedal a bit to where we're coming from. And we had a Court of Appeal decision that urged parties prior to this time to maintain status quo, and now we have this one. And ahead of this time, lawyers had prevailed on the Court of Appeal to make its decision clear enough such that there would not be variations to the interpretation of whatever its decision would be. But this is where we are now, and there is a worry, a very real one at that the Rivers State Assembly could, we could have two state assemblies making decisions for the state government. So is that where we are now?
That is not in existence. There is no problem. Now, there are questions that need not arise at this level. About 2 weeks ago, we were talking about status quo. Luckily now, that has been laid to rest. That arose out of a ruling of the court. Now, that had been laid to rest. Laid completely to rest. We are no more talking about status quo. The court said yesterday, look, don't forget the position before the injunction was given. Please, I want you to always take cognizance of that. The position before the judgment was given, the injunction was given. The position was that Martin Amewule and 25 others were doing their legitimate legislative business before Okojombo went to court to secure that judgment or injunction. And the court yesterday has said, look, that injunction shouldn't have existed or never existed at all because it was given out of jurisdiction. The meaning is that, Like the learned, one of the learned justices said, look, when the matter came before Justice, Wale, that the simple decision Wale would have taken is to decline jurisdiction and revert to the status quo before the matter came before him. That is our law. That is our law. And there is nothing anybody can do to change unless there is an amendment. Of course, there had not been any amendment to that. So the law remains. As we speak, there is no ambiguity. Whatever decision Okojombo has taken, the court says is a nullity, and there is nothing we can do about it. Unless the professor has anything to tell us, anything new.
So I think we'll head to the professor, because it looks like in this matter, the more you look, the less you see. Although you think it's as clear as crystal, but I don't think it's as clear as crystal, because at the end of the day, we have to rely on the rule of law to be able to make interpretation. I understand Prof is no longer there, but do you think that what is going on in Rivers State throws up the question of constitutional lacuna?
What? No. What other rule of law do you require? Justice Omotosho has taken a decision, and that decision is unchallenged.
The reason I'm asking Mr. Oge is that the defection of Martins Chikeamewule and 24 others is even contentious under the 109 subsection 1G of the Constitution. Hold on, Mr. Oge, just a minute. It's contentious because of the premise that the Constitution provides. And the argument is that there was no strong premise enough for them to have defected in the first place. Obita dictum of, I think, Justice Wale, not Justice Bassam, though it's not an enforceable decision of court, alluded to the fact that they are not even members of the APC, although it's an obita dictum because their names are not in the register. That's why I'm asking a legal question. Does this throw a lacuna?
The Constitution provided in Section 109 sub 2 what should happen in event of a defection of a member. It is clear, I've read it. There is no lacuna there whatsoever. The Constitution provides that the Speaker of the House shall give effect.
That is what I'm saying, Mr. Oge. That's what I'm saying. Now the Speaker of the House he defected. The man who should give effect is also one of those that defected.
No, that's why you shouldn't. If that is the situation, if you find yourself in a helpless situation, you don't need to resort to self-help. What is happening is resorting to self-help. So if you find that, assuming you are right in what you said, let's assume they actually defected, and there is no speaker to give effect to it. Do you resort to self-help? Of course, you can't resort to self-help. You will be patient, maybe until you have the quorum to legislate, and the speaker emerges to say, look, in the present circumstance, this is what is before us. So if the speaker is not there, can the legislative house sit in the absence of a speaker or a deputy? Of course, the answer is no. If there is no speaker and there is no deputy, there must be a quorum first, where members will, amongst themselves, elect a speaker. Mind you, Speaker of the House of Assembly is not appointed. The law says it must be elected from members. And for that to happen, members must be in session with quorum. The absence of quorum invalidates everything. So I'm saying this because you still want some explanation. What I'm saying is that there is a sitting assembly where the seat has not been declared vacant. Do we declare it because we want to declare it? Do we declare it because we want to declare it?
Well,
the answer is no.
Mr. Oge.
It is the assembly, it is the members of the assembly that has powers, that Constitution gave the power. The Constitution donated the power to the House to decide or to give effect to such matter. Not for you and I outside. So
all right,
anybody, as we speak...
Mr. Oge, we're totally out of time. I'd like you to land on your points now.
as far as you must mark this, any person outside the 25 members of the Rivers State House of Assembly is an outsider, because 3 persons were suspended, or 4. 1 died, 1 resigned.
All right, Mr. Oge, we're totally out of time. We must end the segment now. We'd like to thank you so much. Pardon me, please, but we'd like to thank you so much for your time on the program. Mr. Samuel Oge is a lawyer and former member, Rivers State Assembly, MOR 2011 to 2015. We also had joining us from Port Harcourt virtually as well, Professor Nwakocha, who is a professor of law, Rivers State University. Thank you very much for your time on the program.
You are welcome. Thank you for having me.